Hello, everyone, and welcome to this webinar of SCL Turkey, which is sponsored by Dentons. So, as you may know, I'm the Secretary General of SCL Turkey, Sercan Kulaksızoğulları, and today we are together with Susanna Fairbairn, Doğan Emirlioğlu, and Dean Ryburn. Uh, uh, and the subject of this webinar will be navigating conflict, change, and claims in the GCC. And by the way, for any regarding the Gulf, any local law questions, Sheriff Janos from Dentons again is together with us. So I now leave the floor to our our guests from Dentons. So you have the floor, Dean, Dawn, and Susanna.
Thank you very much, Sercan. It's a pleasure for us to be here with you and the SCL participants. It's we're very much looking forward to today's exchanges, as the topic couldn't be more up to date, as the region is going through a significant turmoil for reasons we are all too familiar with. So we'll try to address to a certain extent the legal aspects of it, ranging from disputes to joint ventures and what we face. And I have the pleasure of being joined or even led by two extremely experienced colleagues on the matter. On one hand, we've got Susanna Fairbairn, as you said, who's joining us from our Dubai office. Susanna is a partner in Denton's Dubai office. She's part of the construction engineering team, and she does not only contentious but also non-contentious work on all things around construction. And she also has the experience of having acted, I would say, probably if not all, major institutions and rules. So we have a seasoned litigator, dispute resolution, arbitration practice. Shouldn't here with us. But us telling me too much is probably not a good idea. I would refer to Chambers, who has probably had the best words. Susanna is top notch. She's incredibly diligent and has tremendous ability to analyze huge amounts of information and distill it down to a focused advice. I think that's a very accurate description of Susanna, what Susanna can do. So thank you, Susanna, for being with us. Welcome. Next one is our very own Dean Ryburn again. Dean is on top of his excellent lawyering skills and expertise. He happens to have agreed, whether willingly or by force, to manage our Dubai office. You know, office management is always a challenge, but on the remaining time, Dean is also heading the head of our Middle East construction and disputes practice. I wouldn't be too humble if I were to say he's a true star of dispute resolution, recognized by all rankings you can imagine. And he's here with us to share his insights into the general introduction to contracting GCC and also the topical issues that we see in disputes arising in the region. And I'll try to cover the joint ventures aspect of it, because most of the projects that we get entangled with also have a partnership, joint venture, or similar arrangement. I am based in Istanbul. I'm a partner with Dentons. I had the arbitration team here. Have been a transactional lawyer, mainly doing M&A, joint ventures, and shareholders deals for the last 25 years. The last 15 have been coupled with various arbitral appointments, both as counsel and as arbitrator. I sit with the ICC Commission and the advisory board with Istanbul Arbitration Center. So I think you heard enough of introductions and you're looking forward to dive into the gist of the issue. So without further ado, I'll leave it to Dean to guide us through, to provide an introduction to contracting in the GCC and where the real pitfalls and practical tips come into place. Thank you, Dean.
Good afternoon, everyone. Thank you for making the time to join, and thank you, Sercan and Dogan, for the kind introduction. So I'm going to start just by setting the scene a little bit in terms of contracting in the GCC. And I'm just going to spend 10 minutes giving a very quick run through of the legal framework for the GCC countries. And then to the extent I've got some time left, just quickly looking at some of the procurement models. and contracting structures that we are most commonly seeing in the major construction projects across the GCC. And I'll start this introduction looking at the GCC as a whole, but I think as we go on in this, we're going to focus primarily on the UAE and KSA being the two markets which have the most activity at the moment in terms of construction projects. So turning to the legal system, I think any successful cross-border construction project requires a combination of technical execution and delivery, strong commercial management, but also an understanding of the legal system and culture of the jurisdiction where the project's being executed. And I think if I sort of reflect back on my sort of 15 years or so in the GCC and being involved in construction projects, I think one thing that we've seen quite often tripping up contractors, particularly international contractors, is they're very focused on the pricing, obviously for good reason, and on negotiating the terms of their contracts. But I think they pay less attention than perhaps they should to really understanding the legal system and the culture of the jurisdiction where they're doing business. And what that means is they're not fully understanding the way that the contracts will actually be applied and interpreted in practice. So obviously there is a huge amount of difference and nuance amongst the various GCC countries, and it's not possible to deal with all of those in the limited time we have. But let me start by just highlighting some points that apply across the GCC. So the first is that all of the GCC countries have a civil law-based legal system with influences to varying degrees from Egyptian civil code, Islamic Sharia law principles, and local commercial practice. Secondly, since the introduction of the Saudi Arabian civil transaction law in December 2023, all of the GCC countries now have a civil code that governs and codifies the primary laws relating to civil transactions. And these include everything from issues about contract formation, interpretation of contracts, mandatory provisions of law, and they also include specific provisions dealing with different types of contracts. And of relevance to us in the construction industry are the provisions dealing with mukawala contracts, which are essentially contracts for provision of services and cover all construction contracts. And again, all of the GCC civil codes have these specific provisions. Now, the civil codes cover a number of themes, such as the role of good faith, decennial liability, limitations of enforceability of certain exclusions, and also the court's powers to recharacterize or rebalance contractual provisions in some circumstances. And just on that last point, that's most commonly been looked at in terms of liquidated damages provisions. But obviously in the current regional conflict, that is now being looked at far more closely in terms of the wider obligations, and that's something we can pick up a little bit more later on. Just quickly in terms of the court system, again, there are a number of common features. So proceedings are typically conducted in Arabic. Cases usually move from a court of first instance to an appeal court that can look at both facts and law, and then on to a final court of cassation or Supreme Court on questions of law. The local courts across the GCC, I think it's fair to say, provide relatively fast and cost-effective resolution of disputes compared to arbitration. However, a key feature of GCC court litigation is that the courts will appoint an expert to report on technical matters. And in construction cases, the technical matters often encompass all of the substantive issues in dispute, or very many of the substantive issues in dispute. And the court will then often adopt the decision of the technical expert, and that will form a key part of the judgment. As a result, the outcome in the local courts is often very heavily influenced by the experience and ability of the expert to really engage with and understand the technical issues, and also the quality of the engagement between the parties and the court-appointed expert. And I think when you think about the complexity and scope of many of the construction projects going on in GCC, and particularly the construction projects that we see Turkish contractors involved with, you can immediately see the challenges that are presented when you're relying on a single court-appointed expert to decide or give an opinion on a number of these key matters. And I think it's for this reason that we see all parties to construction contracts, and in particular, international parties, typically prefer to have their disputes resolved by arbitration. So that's obviously a very quick overview of the legal system. There are, of course, a few important caveats which I should just point out. The first is that in addition to the civil law court systems in all of the jurisdictions, there are a number of free zones that you may come across. So we have DIFC, ADGM, and Qatar Financial Centre. All of these have their own common law commercial laws, and also their own common law styled courts. We're not going to spend too much time on those, however, because although any party can opt into them, we don't typically see them in construction projects. And I think where you're most likely to come across those jurisdictions in construction projects is going to be in the context of the seat of arbitration. The second thing, which I think is very important, is often misunderstood or not sufficiently appreciated, is although the civil codes cover a lot of the same points, there are very significant differences between how the different jurisdictions deal with these. And I think this is quite well illustrated if you just look at the UAE and Saudi civil codes and where they're actually derived from. So the UAE civil code is primarily derived from the Egyptian civil code, with significant influence both from Islamic jurisprudence and the Ottoman Majalla. In contrast, the KSA civil code is primarily derived from codifying Sharia law principles. And although it does incorporate some provisions that have sort of been borrowed or come from the Egyptian civil code. And so obviously that means you're starting from a completely different starting point in those two neighbouring countries. And I think if you bear that in mind, you'll begin to appreciate why there is so much nuance and why it is so important to treat each jurisdiction separately. Also just worth mentioning, the civil codes sort of came in the 80s and 90s across many of the jurisdictions, but there have been very significant changes recently. I mentioned before that Saudi Arabia has, for the first time a couple of years ago, brought in its own civil code. In the UAE, there is a major update to the civil code that is going to come into effect on the 1st of June. So again, I think it's important not just to sort of fall back on understandings from projects in the past. There is a lot of change in this area, and it's important to understand that. And then the final point is, obviously outside of the civil code, there are a huge number of regulatory issues that are going to differ from jurisdiction to jurisdiction, and in the case of the United Arab Emirates, will differ from emirate to emirate as well. So these are things like local content requirements, localization, which is a big issue in the Middle East, and then things like building codes, technical standards, permitting processes, health and safety. All these types of things are obviously another level that differs very significantly. So then just moving on very quickly, just to talk about some of the contract structures that we most commonly see. And I think when you're looking at projects in the Middle East, it's often useful just to categorize them. And I would look at this sort of three key categories being real estate, infrastructure, and PPP projects and utilities. So starting with real estate projects, I think the most common procurement model that we're still seeing is contracts based on the FIDIC Red Book. And very often they are based on remeasurement rather than lump sum. And the reason for that is typically these projects are being commenced at a time when the design has not fully been finalised. Then if you move to infrastructure, and in this case, I'm thinking particularly of some of the big infrastructure projects in Saudi Arabia that are being procured from the government. We're seeing a lot of those being procured on a design and build basis, usually using bespoke contracts, but again, often bespoke contracts on a lump sum payment basis. Often those contracts are having significant influence from the FIDIC forms. And I think if we take both of those for the real estate and infrastructure projects, obviously all of the typical issues are being negotiated. But the two that I think we see being very prominent in the GCC in particular are issues around design responsibility. Again, the design is often poorly developed when the projects are launched, and there's often an attempt from employers to push as much of that design responsibility onto contractors as possible. And then the second one is the sort of typical time and cost relief events. The third category of projects are sort of project finance, PPP projects. So we're seeing this increasingly across a range of different industries now, but most commonly power, water, wastewater, district cooling, those types of projects. They are all procured on an EPC basis, and really the key principle there is passing through the risk from the offtake agreement. And unsurprisingly, then what we're seeing is a lot of focus and negotiation is around the equivalent project relief clauses, the way that those obligations are passed through, the exclusions of the risk, and then also around the testing and commissioning requirements. So just before I wrap up this section, maybe also just to make a general comment on risk allocation and contracts in the GCC. I think historically what we've seen over the last 10 or 15 years is employers very aggressively pushing huge amounts of risk onto contractors. And I think that has been a big problem for the industry. I think encouragingly, we are starting to see that shift a little bit. And Susanna sort of led a project with ADPEC, which is part of the Abu Dhabi government, where they expressly recognise that and have gone out and consulted with contractors and employers and put out a new standard form contract that was specifically designed to have a more reasonable risk allocation and is being mandated for a lot of Abu Dhabi government entities. So I think that's a positive development. Equally, in Saudi Arabia, it's by no means consistent, but we are seeing a lot of the major developers taking a far more balanced approach to risk. I think, again, recognising that the success of the project requires a sensible risk allocation. So, again, that's encouraging. And I think what I would say to people who are involved in negotiating contracts is I think there is a lot more scope to push back on risk allocation and get more sensible risk allocations than may have been the case previously. With that, I will pass over to Susanna. Oh, sorry, I'll pass back to Dogan to talk about joint ventures.
Thank you, Dean. That was most. Go ahead,
Sorry,
Susanna.
one second, just to intervene. I just have a reminder for our audience. So we will have a Q&A session at the end of the presentation. So if anyone in the audience have any questions regarding the content of the webinar, please submit your questions through the Zoom's Q&A system, and we will be answering your questions at the end of the presentation. So my apologies, Don.
No worries at all. It's always great pleasure. As mentioned at the onset, before we tackle those major projects, it's maybe worth a moment to spare on who gets to do these projects. And we see more and more, given the sheer size and the financing requirements, we see more joint ventures. So we wanted to tackle that and share our 2 cents on the typical issues and the practical tips that we thought might be useful when engaging in a major infrastructure or construction project in the GCC. And it naturally consists of typically two components. The first one I would call the acquisition phase, assuming that you are not setting up your JV from scratch and there will be a new entity. You're buying into an existing entity or a special purpose vehicle that has been already set up by the local partner, and you buy into this, and that entity becomes the contractor. So there's a bit of a classic M&A element at the onset, which in a region where, despite the civil law heritage, the M&A practice has been heavily influenced by, like the rest of the world, by English law and some other elements of the broader Anglo-Saxon legal world. So it's always more art than science to figure out how you can come up and negotiate a contract that is locally enforceable on the back of civil law regulations and codification, using a contract that has been heavily designed or adopted as market practice on the back of English or American M&A contracts, such as share purchase agreements. The one thing that's always to be kept in mind, and that's where we see also issues or even disputes coming up, starts as early as the due diligence phase. We know that most investors are always under pressure to manage costs, and the very first victim of that process, compared to, say, early 90s, early 2000s even, is the budget's spared for due diligence. This is now being considered almost, in particular by certain investors, as check the box exercise. You send out a questionnaire, you get sketchy answers, missing ones, complete ones, some that are obscure, but you're in such a rush to get the deal done that the due diligence gets neglected. This is a perfect recipe for disaster unless you can recover that during the negotiation of the liability regime in your share purchase agreement. The good old Roman principle of caveat emptor, buyer beware, is generally applicable. So if something is disclosed to you and you simply overlook it, then it is considered to be in the domain of the buyer's knowledge and you would not be able to raise claims on it. So while due diligence gets diluted, the practical approach would be if you are not fully satisfied with your due diligence findings or the quality of the information made available to you is not that good, you will have to make up for it through contract negotiation and liability regime. There, the disclosure element becomes very critical. And often in modern practice, we see disclosure being one of the most heavily negotiated elements of a share purchase agreement. Typically, sellers have a tendency to say everything in the data room should be considered as disclosed, therefore, in the knowledge sphere of the buyer, releasing the sellers from liability. And the buyer obviously would prefer a somewhat more tedious, but what I personally find to be a more balanced approach, say, we cannot be considered to have absorbed and understood and analyzed every single possible outcome of a one-page report in a due diligence data room. So we need to come up and agree on a disclosure letter where you as the seller, who knows the target entity where we're buying the shares better than anyone else, tell us the specific exclusions or exemptions to the warranties that we're asking on the target company. And then we are in classical negotiation territory. So that's usually the most challenging or time-consuming part of the acquisition phase. The second one is more financial than legal. And I see this coming more and more to the forefront as it triggers a lot of disputes as well. Most of the time, there may also be a purchase price adjustment, in particular if the joint venture vehicle is an entity that has been operating for a while and you are forming a true partnership in that jurisdiction to move on with projects in that jurisdiction. The challenge does not arise from coming up definitions of cash, debt, what's the required net working capital arrangement. The devil is in the detail. Most lawyers may have a tendency to go with rather well-established templates, and the definitions and the concepts used on those templates often work until they don't. Because one thing that gets often overlooked is the underlying accounting regime and the accounting codification in the country where the target is located. If you're trying to negotiate your financial definitions on the basis of IFRS, that's one thing. But if the financials of the company are based on the local accounting system, and there are always minor differences between the local accounting rules and IFRS, or whatever accounting standard you want to use, you always need to be very careful where those differences are, because they can translate into significant sums in terms of whether a particular item goes into a liability section or a receivable section, and that has a huge impact on the pricing of the deal. So the very practical tip that we would have would be to make sure that when you're negotiating your financial definitions is to make sure that you have a good alignment and a good understanding of those definitions covering everything that needs to be covered in light of both the international and the local accounting standards. We could have an entire seminar on it, so I won't waste any more time and probably move to the second phase, which I would call the partnership phase. The deal is done. You just incorporated your joint venture or you bought into the target vehicle, and now you have a partner with which you need to manage the project, but also the company, which typically triggers a number of sensitive topics to be negotiated and then managed throughout the life of the joint venture. The very first one is probably one that pops out by the time you're making the choice between having an incorporated joint venture or an unincorporated joint venture. For those civil lawyers, the latter one is also called a purely contractual joint venture. So there is no company in place. It's a joint venture. It can contract, but it is not in incorporated form like a joint stock company of a limited liability partnership or anything else. The very first thing that pops out with that form of collaboration or cooperation is the liability of the partners in the joint venture vis-a-vis the external world, vis-a-vis third parties. Most jurisdictions have some rule that says, we do not care how you regulate it internally in terms of recourse and how you share the tasks, but as partners of an unincorporated partnership, you're jointly liable towards third parties. Chief amongst them is naturally the employer. So that's one thing to really consider by the time you start choosing the form of joint venture, and then also negotiating the internal recourse mechanism, task sharing, and liability and recourse regime between the partners. Once you get past that, there is typical shareholders agreement type elements that need to be considered. Chief amongst them is obviously governance. Who gets the appointed board, who can remove members of the directors, who's authorized to represent and bind the company. And more than often, we've seen those governance requirements having to be translated into the articles of association of the local entity. And more than often, it is not a copy and paste exercise because the local commercial laws and the civil code would intervene saying that there are certain things you cannot inscribe in the articles of association, which are typically public documents. And even if you have in jurisdictions where you have a larger freedom to do so, you may prefer not to do that simply for confidentiality reasons. So negotiating those governance provisions, creating different classes of shares, and how you enshrine them in your articles of association is going to be the next step in your negotiations, the next challenge on getting the deal done. The second most troublesome or prone to disputes part we observe is the option rights. And by that, I mean typical share purchase or sell provisions such as put options, call options, tag-alongs, drag-alongs. And I will overgeneralize here on purpose, hoping to provoke questions as well now that we have Dean, Susanna, and Sharif around. Most of the time, investors operate under the assumption that if you write a beautiful market practice option clause, you will have access to specific performance as a remedy, therefore the opportunity to acquire title over the shares. Most of the time, that's not the case because specific performance is not a magical wand that would allow you to acquire title over the shares simply because you have a valid clause. Local laws interfere, sometimes even refute specific performance as a remedy. So you need to come up with alternative fallback scenarios. The use of escrow agents, depositing of shares into escrow, how you release them, that's another set of negotiations. Then if that doesn't work because escrows are not always available in every single jurisdiction, then you find yourself typically in a world of negotiation where you have to come up with some sort of liquidated damages or a contractual penalty provision to serve more as a deterrent stick and discourage default than actual carrot to acquire title. That we see the amounts of those contractual penalties vary significantly depending on the risk appetite of the parties and also their legal backgrounds. For a Swiss, German, or Turkish entity, they're freely negotiable. The sky is the limit because both entities are commercial enterprises. But on other jurisdictions where people come from more equity or predictability requirement being enshrined in their laws, English law is typically a good example of that too. Contractual penalties are not enforceable. You need to come up with a best guess estimate translating into liquidated damages. So there's a fine-tuning to be done there. And the key to start all of that is to get rid of the assumption that your option rights will eventually get you the shares. It's always more prudent to assume that your primary remedy is damages, and make sure that your contract is structured in such a way that at the end of the day, you have access to a very clear damages calculation and damages claim if specific performance is not available. The third type of disputes that we see coming out of joint ventures, and therefore are worthy of consideration when you're drafting your joint venture agreements, is the earn-out provisions and the exit arrangements. In particular, if you have the technical expertise and you're dealing with a financial investor, such a private equity house or a sovereign fund that is playing the pure role of the funder of the project. They have a limited shelf life. So they would like to see results and an opportunity to exit, which will bring you back to the option rights, in particular in the form of the puts and drags being negotiated heavily. But another hidden issue is typically on the earnout. Sometimes your investor, which may be a bigger strategic player, is willing to keep you in the project, in the joint venture, to get it off the ground, but at some point they would like to assume full control. And you, naturally, would have an incentive to ask for payment for value that you create during the earlier years of the JV where you get it off the ground. This is typically done through the earnout payments. And there's, again, a rather detailed and tedious negotiation on how you value the company 3, 5, 7 years down the road. What will be the mechanics? What will be the accounting rules? Is there going to be a floor to the valuation compared to the date where you did the deal? And here, again, the careful drafting and negotiation are the keys to sleeping much more soundly at night. I'll stop here and defer the rest of the discussion and to the Q&A part. But like everywhere else, JVs in the region are tricky business, and it's probably where disputes are settled even before they arise. So it's always important to figure out how you're going to manage your JV and negotiate accordingly. But I'm sure Susanna has a lot more to say on what follows. Thank you.
Can I just add very quickly? I mean,
Sure.
I agree with all of that. We are seeing a very significant uptick in disputes around JVs and between JV partners over the last few years. I think it's been a very clear trend. I think part of that comes down to a lot of the factors you were talking about. There's often a conflict of interest in terms of the different roles that the JV partners are playing. The exit and option, I've never seen one in the Middle East that works. I think there's not enough attention paid to how that interacts with the local law and the governance requirements. And maybe just flag two more things. What we've seen a lot is the governance is not being properly thought through, and we're then seeing parties try to take advantage of that by threatening various claims against directors individually for failure to comply with their various duties to apply commercial leverage. And the other thing we've seen a lot of international parties be really stung by is where one of their joint venture partners has gone into insolvency and they've ended up taking on full liability for projects. Obviously, we could talk about this for a couple of hours on its own, but I'll
Exactly.
hand it.
Yeah, thank you, Dean. Right, Susanna, back to you.
Excellent. Thank you all, and thanks for being here. It's a pleasure to be with you all today. So, Dean, I think if you could just move on to the next slide, please. So yeah, Dean and I spend the vast majority of our time advising contractors in the region on dispute avoidance and dispute resolution. And there are the same issues that we see come up again and again, particularly in projects with government-related entities. So we thought we'd just spend a quick bit of time whizzing through these and the key things that you should be aware of for each of these topics. So each of these could probably be its own training topic. So just going to focus on a few of the really key points. So starting with defects, these are usually governed by the contractual terms, and those will generally be enforced by the courts or the tribunal. If there's negligence, then liability may also arise under the law. The employer is usually expected to give the contractor an opportunity to rectify the defects themselves before instructing a replacement contractor to do so. That's usually specified in the contract anyway, but it's also generally expected by a court or tribunal, even if it's not specified, due to the duties of mitigation under most of the civil codes. And then one key thing to be aware of for defects is decennial liability, which is mandatory under the civil codes. And I believe you've got similar in Turkey. It's a strict liability on contractors and supervising architects, and it applies to a total or partial collapse of the building or any defect threatening the stability or safety of the structure. And in both the UAE and KSA, it's applicable for 10 years from the delivery of the works. And then the limitation period, so the employer has to bring the claim within 3 years from the collapse or the discovery of the defect. And the compensation for decennial liability isn't limited to the cost of repair. So it can include the loss of use and loss of profits. And in the KSA Civil Code emphasises that restoration must be to the original position that the party would have been in if the harm hadn't occurred. And decennial liability is a mandatory obligation, so you can't contract out of that. Delays in mitigation is obviously another repeated issue, not just in the GCC, but particularly due to late and undeveloped designs and variations instructed during the course of the works. Under the law, as I mentioned, mitigation is a core duty in both UAE and KSA, and the contractor is generally expected to take reasonable steps to mitigate, even when its employer caused delay. Key issue is often concurrency. There's no set definition of concurrency in the codes and no defined way that it's dealt with, but it's usually dealt with by way of apportionment, because that's in line with the general principles under the civil code, such as reducing compensation where the claimant is also partly responsible for the loss suffered. And delays leads on to liquidated damages. So liquidated damages are almost always included in the contracts that we see. They're applied automatically by employers, often up to a cap of 10%, and they're usually applied regardless of actual loss. So under the law, again, in both KSA and the UAE, parties are free to agree in advance the amount of any compensation. So liquidated damages will generally be enforced by the courts and the tribunal. But the courts and tribunal do have the power at the request of a party to increase or decrease the amount that's agreed so that it's equal to the actual loss suffered. So usually we see that contractors trying to reduce the level of liquidated damages. The difficulty there is usually that the burden lies with the party trying to change the value of liquidated damages. So often, obviously, it's difficult for a contractor to prove that the employer's loss was less than the agreed amount. We also do sometimes see employers trying to rely on this to increase the value of liquidated damages that they're entitled to. And again, this is a mandatory obligation, so you can't contract out of the ability of the courts to adjust the sums. Now, this is changing a bit with the new UAE Civil Code that Dean mentioned is coming in on the 1st of June this year. So under the new code, parties can still agree liquidated damages and the courts still have discretion to vary the liquidated damages. But the court's discretion must now follow quite strict statutory criteria rather than just being a broad discretion. So under the new civil code, the courts can reduce the LDs if they're exaggerated or if they're found to be partly unjustified or if the employer contributed to the delays. And then key to note is under the new law, liquidated damages can only exceed the amount agreed if there's fraud or gross fault has been proven. So that helps limit the amount that employers are going to be able to try to increase their liquidated damages. And again, parties can't contract out of it. Limitation of liability. So there's heavy reliance on liability caps across the GCC. Typically, we see 100% of the contract value. Agreed limitations on liability are generally enforceable under the law, but legally, there's some carve-outs that you must have. So you can't limit liability for tortious harm, liability for fraud or gross negligence, death and personal injury, and decennial liability. And it's also common to carve out, but you don't legally have to carve out third-party claims, insurance proceeds, indemnities, and liquidated damages. And then notices. So there's no direct guidance under the law as when notices will be enforced as condition precedents, but they're generally enforced if the contract wording is clear enough. So if it includes a specified time for filing the notice, and if it states what the effects will be. And that's generally in line with the civil code principles that the contract is binding on the parties. But the courts and tribunal will fairly often adjust that if you can persuade them that it's contrary to good faith or would result in unjust enrichment or results in benefits that are disproportionate to the harm suffered. So it's very important to file notices on time. They may well be enforced as condition precedents. But if you don't and you end up in a dispute, then we can try to persuade the tribunal that they shouldn't be strictly applied, but that can't be guaranteed. And then again, to be aware of under the new UAE Civil Code, there are some mandatory notice provisions hidden in there. So, for example, if defects appear in the materials provided by the employer or other factors arise that would impede performance, then the contractor shall immediately notify the employer. And if he neglects to do so, then he's liable for the consequences. And then just quickly, security. So bonds and guarantees are very prevalent throughout the GCC. In the UAE, we usually see parent company guarantees, very common, especially where the contracting entity is a subsidiary or special purpose vehicle. Bid bonds usually provided during the bid process to guarantee that the bidder will honour the terms of the bid. Performance bonds are really key, and we see these used a lot in disputes. So they're typically held from the commencement of the contract until taking over or the end of the DLP. And most performance bonds in the UAE and KSA are issued as on-demand bonds by banks or financial institutions. So when they're called, the bank is required to pay the employer on demand without investigating the underlying contractual dispute. And yeah, retention bonds as well. So employers regularly hold a retention of the progress, and that's sometimes held by way of security. And advance payment bonds are also common. So due to the on-demand nature of the bonds, we frequently see threats of calling the bond used as leverage, especially in the pre-dispute phase. So when a contract is nearing completion and the parties are starting to argue about the final account, the UAE courts will uphold the autonomy of on-demand performance bonds, and they rarely intervene in payment unless some kind of fraud can be proven, which is very difficult. So we often see them paid out, and then the contractor needs to seek to claw back the amounts. In the UAE, if the bond is called, you might be able to seek an attachment to prevent it if you act quickly enough. But then you need to commence a substantive case within 8 days. And then pay when paid and pay if paid clauses are also very common. They're generally considered enforceable by the courts, provided that they're clear and unambiguous. They're often used, as a means for the contractor to protect itself to some extent in instances of non-payment and pass certification risks down to subcontractors. And then finally, nominated subcontractors. So we frequently see nominated subcontractors on projects. Unfortunately, they're often not chosen because they're truly the best for the works. The main contractor is responsible for the nominated subcontractor, and this is enforced by the courts and the tribunal. It often leads to coordination nightmares, and main contractors are often held liable for nominated subcontractor delays that they can't control. And we also often see nominated subcontractors and employers bypassing the main contractor, both during the project and sometimes during disputes as well. There is a new law in Dubai regulating contracting activities, which now requires all subcontractors to register and for subcontractors to qualify based on technical and financial capacity, not just on price. So it's hoped that this might reduce the forced nomination of weak subcontractors, but it's a very new law, so keeping an eye on that. Okay, that's a very quick whiz through some of the key issues that we'll see, and I'll pass over to Dean to deal with some of the most topical ones.
Thank you, Susanna. And just to continue the trend, I think we will go through this very quickly as well again. I don't think it will be a surprise to anyone to know that there is a huge amount of focus across the GCC on the implications and consequences of the current regional conflict. And where that is sort of starting, I think, for a lot of contractors is a discussion around force majeure. And so I'll just very, very briefly go through this. Is again something that Susanna and I could, and Sharif could talk about for hours, and indeed we have been speaking for many hours to clients about these issues. Obviously, the starting point for a force majeure event, so actually I should say at the start, when you're talking force majeure, particularly in construction contracts, I think the focus needs to be on the contractual provisions first, and we'll come to the reason for that later. But most construction contracts will have some sort of force majeure provision providing relief within the contractual terms. There are obviously a number of elements, foreseeability, outside of a party's control, inability to mitigate, that go into a force majeure definition, and each clause needs to be looked at on its own merits very carefully. But one of the features that we've seen coming up, and one of the big issues, is what the threshold is in terms of, does that event need to hinder the party's performance, or does it need to prevent a party from being able to perform? And a lot of the clauses we're seeing in the Middle East actually require prevention of performance, and that is a very high threshold. So there is case law, both under English law and under UAE law, saying that prevention of performance doesn't mean that it simply becomes more expensive or more onerous. It means that it's effectively impossible. And so I think that is a shock to a lot of parties, because they're not expecting, they're thinking that within the general force majeure provision, they should have relief, and that's not always the case. Having said that, I think there are arguments that can be made around that, and in particular, looking at whether it's preventing performance. So a party, for example, may be able to spend money to mitigate, to accelerate, and still achieve the overall project. But there is an argument to be made that they're being prevented from performing in accordance with the contract, because the contract may have an implementation schedule, may have quite strict specifications. So there is some room for argument around there, but I think it's more difficult than a lot of parties initially assume it might be. I think that the second key issue we're seeing coming up a lot is, if you get through the general definition of force majeure, what most people, or most contractors in particular, are looking for at the moment is some sort of cost relief in addition to the time relief. And the way most contracts in the Middle East are structured is that there is a standard force majeure provision which gives time relief, and then there's what's often called political force majeure, or sometimes an employer risk event. And it's only if you fall within that more limited subset of force majeure that you are entitled to some sort of time relief. Now, usually those will list specific force majeure events, and it's quite common that they will list things like war and armed conflict. So again, on the face of it, you might be thinking, right, I'm within this political force majeure event. But when you look more closely at a lot of the clauses, there are some quite important exclusions. And one of them that we see very commonly is that the political force majeure event is restricted to events happening within the relevant jurisdiction or to impacts within the relevant jurisdiction. So, for example, in a project in the UAE, it will often say an act of war or armed conflict will be a political force majeure event to the extent that it occurs within the UAE. And I think the obvious problem that presents to a lot of parties is a lot of the impact we're seeing is obviously supply chain disruption that is occurring as a result of the shipping delays. And in many cases, that's not going to be falling within the jurisdiction in which the project is based. So again, that can be quite an important limitation to obtaining that relief. Even if you get through those definitions, obviously then you've got to start looking at the issue of causation. And I think, again, this is an area that a lot of doesn't necessarily get the focus it should do. So the party claiming a force majeure event bears the burden of proof. And they've got to show causation from the specific impact that they have suffered, linking it back to that force majeure event. So it's not something that can usually be done on a project-wide basis. You've usually got to dig in to quite a lot of detail and identify the specific impacts that have been suffered, and then show that clear chain of causation back to the armed conflict or act of war. When doing that, I think it's also important to think beyond the obvious impacts. So there are some, sites are being closed and, things like that, which are obvious, but there are a huge amount of secondary impacts around things like insurance costs, supply chain issues. And I think it's important that parties start thinking about those early so that they can get those within their notices. It's also very important to make sure you create and maintain a paper trail if you do have a force majeure event, because again, the party asserting force majeure has a burden of proof. They have to prove that causation, but they're also going to have to prove things like mitigation. So showing that they have, not just having discussions, but actually having documentary evidence of all the alternative mitigation options that have been considered and why they might have been dismissed as not being feasible is going to be extremely important. We are seeing in some jurisdictions, the counterparties are accepting that there was a force majeure event, which is a good start. But again, I think the risk then is parties get complacent. They don't follow through with providing those additional notices with the additional evidence. And then when they come to claim it at the end, they're going to have a very difficult time, although they may have established force majeure, actually proving the cost or time relief, I think, can become quite difficult. Obviously, most contracts have strict notice provisions. I think they need to be complied with. But I think from a practical point of view, again, would say don't be complacent because you put that notice in. It's important, this is a quickly evolving situation, and following up, providing those further details and further information as it comes about, I think is going to be extremely important. And then the final thing I would say on that is we have seen, a lot of parties sort of quite reactively issuing force majeure notices. Most of the time that's fine, but I think it is important to take a step back and really look at all of the other contractual provisions and potential reliefs that you might have, because we have seen examples where parties have actually asserted force majeure when in fact they had a better entitlement to relief. So in one case, we had a client who actually had quite a clear entitlement for a failure to be given site access, but by asserting it was force majeure, it was actually potentially counterproductive. And so I think there are a lot of other provisions that need to be looked at in a sort of overarching strategic view taken of the situation before just assuming that the force majeure provision is necessarily the one that's going to provide the best outcome. as I mentioned, there are obviously a lot of limitations on that. So force majeure is not going to be as helpful in a lot of situations as parties might hope. In that case, we can then turn to local laws across the various GCC countries. Again, there's a lot of similarities and some differences, but if we take UAE and KSA, for example, they both have force majeure provisions within the civil codes, but I think we can dismiss those because generally, again, they require an impossibility of performance. So it's at least as onerous as contractual provisions. And most of the time what we're seeing is those civil code force majeure provisions don't assist. But what is also in the civil codes, again, of both the UAE and KSA, is a doctrine of hardship, which applies where there are exceptional, unforeseeable circumstances that make performance more onerous. And the key point there is it makes it more onerous. It doesn't make it impossible. So in the situation most of our clients are finding themselves in, where they can perform, it's just more expensive, the hardship doctrine potentially offers a way through that. The other thing that's important about the hardship doctrine is it is a mandatory provision of law both in the UAE and KSA. And what that means is parties cannot contract out of it. So that's something we think is maybe not quite getting enough attention. If what those provisions allow is for the parties to seek to renegotiate. If they're unable to renegotiate, the court has a discretion to intervene and rebalance the contractual obligations. And I should emphasize at this point as well, it is a very high threshold. So we have not seen a huge number of successful cases through hardship. Having said that, Sharif, who is on this call, is one of the few people I know who has successfully run cases and had contracts adjusted on the grounds of hardship. The other thing I think is important from a process point of view, because it is a discretion of the court rather than an entitlement, we think it's potentially quite important that you notify if you think that applies, you notify your counterparty. And then if you have an arbitration clause, that discretion then vests in the arbitral tribunal. And we think there is at least quite a strong argument that you actually need to raise that arbitration now because it's a forward-looking discretionary relief rather than waiting to the end of the project, because I think there is a risk if you wait to the end of the project, you will lose your ability to rely on that hardship doctrine. So that's something certainly we think parties should be looking at a lot more closely. We're giving a lot of advice on. Conscious of time, I just very quickly pick up on suspension and termination. We were seeing, I think, prior to the conflict, a lot of reprioritization of projects, in particular in Saudi Arabia. And what that was leading to is a lot of suspension and termination. We obviously expect, depending on how things play out over the coming months, there may be further reconsideration of projects. So this may continue to be a very hot topic. Unsurprisingly, I think where projects are being reprioritized and not completed, they're not providing the return that employers were expecting. And we're seeing a couple of consequences of that. One, employers are trying to find alternative grounds to justify the termination so that they don't have to pay out the full sums that they would have to pay out if they just accepted it was a termination for convenience. So we're seeing employers try to dress this up as de-scoping rather than termination. And we're also seeing employers trying to rely on allegations of default and trying to dress up what appears to be a termination for convenience as a termination for contract default. So I think, and then the second thing we're seeing is employers are then pushing back on a lot of claims that had accrued prior to the date of termination. So I think that the takeaways from that is, I think if you have a project that you think may be subject to reprioritization, I would act fast. Don't wait. I think things like notices, claims, records, correspondence that is happening at this time is all going to be extremely important to the position you find yourself in and how successful you're able to be in terms of challenging the basis of the termination, but also asserting and recovering your contractual rights, both for events that accrued prior to termination, but also the consequences of termination. I think that has brought us to an end in terms of the presentation right on time. So Jan, will maybe hand over to you for any questions.
Yeah, thank you. So we have one question coming from one of our members from Iran. I think the question is directed to Susanna. So the question is, in a situation where a contractor is contractually responsible for nominated subcontractors, how would courts typically approach liability if, prior to contract execution, the contractor expressly raised concerns about the nominated subcontractor's financial stability, yet the employer insisted on their appointment, and the subcontractor subsequently became insolvent during the project? And to what extent might that prior warning shift risk or affect the contractor's responsibility?
Okay, thanks. I'll let Sharif and Dean add anything they might have in a minute, but generally that won't shift the responsibility. So we often see contractors trying to raise potential issues with nominated subcontractors before the contract, unless you can get that, get a kind of carve out written into the contract, which we do sometimes see negotiated, but again, depending on the employer. Unless you can get the carve out written into the contract, then generally the contractor will still be held liable for the nominated subcontractor, even if they raised concerns before the contract was entered into. Sharif, Dean, I don't know if you've got any alternative.
Yes, thank you, Susanna. So just one point here. If we assume that the UAE substantive laws are applied, so the starting point is still that the main contractor remains liable to the employer for subcontracted work. Because when we get basically the commonly cited UAE civil code provisions say the contractor may subcontract, but between brackets, the first contractor shall remain liable as towards the employer. And the subcontractor has no direct claim against the employer absent assignment. So basically, it's all about like the risk would be on the like in these kind of cases. Usually, like there is like UA commentary which reaches that same practical point that nomination can open a defense of causation, even though that Article 819 itself does not distinguish nominated from domestic subcontractors.
Yeah, and I'll just add to that as well. I think most contracts here, as I say, are often based on the FIDIC form, and I think the FIDIC form anticipates that the remedy for a contractor who doesn't like a nominated subcontractor is to refuse to enter into that subcontract. Now, commercially, I think we all know that is extremely difficult and perhaps unrealistic. But unfortunately, that is the situation, and it is a cause of a lot of problems that we see on projects.
Thank you for your answers and comments. So while maybe our audience is thinking on further questions, I just have a few reminders on our events, actually, for SCL Turkey's events. So tomorrow we'll be having a joint event with SCL Romania in Ankara in the Contractors Association building. And we will have 3 sessions on investments in Romania and similar subjects, and the construction contracts in Romania as well. After that, on 11th of June, we will be having our annual construction law conference in Le Méridien Hotel in Etiler, Istanbul. So it will be a full day event packed with sessions plus the networking opportunities through the coffee breaks and lunch and the cocktail reception. And lastly, we will have the European Society of Construction Law's annual event in October, on 23rd and 24th of October. And this will be actually, again, a one-day full event, plus to be followed by a workshop on Saturday morning. And the theme of that event will be the global turmoils, which we somehow predicted actually last year. And global turmoils and the uncertainties in construction projects. we already passed the deadline for abstract submission for the event, but we will still be accepting abstracts if anyone wish to submit. So for further evaluation until the event date. So I guess our audience has been quite content about your presentations, and I guess we will be concluding the event. Do you have any last remarks, anyone from your side? Susanna, Doğan, Dean, or Sheriff?
I would let Susanna and Dean lead the way. Ladies first, as usual.
No, nothing from me. Thank you. Other than to say thanks all for coming.
Okay, well,
Yeah.
thank you. It's
Dean?
been a genuine pleasure for us, and we'll look forward to the next opportunity.
Thank you, and thank you for your support to SCL Turkey, and thank you for this webinar, and hopefully we'll be seeing you at another event. Thank you, everyone, and for the audience, thank you for joining us. Thank you, everyone, and have a lovely evening.
Thanks, everyone.
Thanks,
Thank
all.
you. Bye-bye.
Thanks.